Hi, I'm Kurt Harris with the Men's Family Court column. Today I want to talk to you about temporary protective orders, or also known as temporary restraining orders. In a domestic situation, when you've been involved with a party in a relationship or married, there is a temporary protective order that can be issued against you by the temporary protective order court. And that is an order to stay away at least 100 yards from the other party, or from your work, or from the children's school, or whatever that happens to be. Those temporary protective orders are issued by the courts upon an affidavit that's signed by somebody, which is a sworn statement of someone saying that they are in fear of their lives or serious bodily harm to be brought upon them. It isn't always verified at the time that that protective order is issued. The difference between a restraining order and a protective order is generally the protective order is issued in a domestic situation, and a restraining order would be issued in a non-domestic, or when you haven't been in a relationship, when it's a neighbor across the street or someone that's harassing you. That would be the difference between the protective order, or a TPO as they're called in the family court system, and a TRO as they are issued in the other courts, the justice court system here in Clark County, or in your jurisdiction it could be a little bit different. But what to do? You can obtain a TPO, temporary protective order, by going down and filling out a sworn statement and stating why you are in fear of your life or of serious bodily harm. That's a sworn statement that the courts take very seriously. And if you do that, a temporary protective order can be issued after review by the governing bodies there, and they would serve that upon the other party. What happens if you get served? If you're served with a TPO, the main thing that you do is not contact the other party. Don't go to the house. Don't try to talk to them. Don't try to communicate with them. You can be held responsible for a violation of that protective order. Now, I find many times with my clients, they find out about the TPO from their spouse or their future ex-spouse or their ex-girlfriend who said, I've got a TPO against you. And the first thing they do is they want to go over there and they talk about it. That's a really bad idea. When the TPO is mentioned, it's a good idea to break off the conversation and go your separate way. And how to deal with a TPO. Many times when a TPO is issued, you may know it, you may not know it, or you may have been served with it, but you have an event you're going to that was pre-planned and you know that you're going to be there. If that TPO is against you and you show up and the other party is there, the best thing to do is to leave as soon as you can. The TPO is issued against you and not the other party. The other party can't violate that order. That order prohibits you from coming into contact or within 100 yards of the other party, whatever the order happens to say. You need to respect that. You need to abide by it. It also prohibits contact via text or by phone. It's a horrible idea to break it by making a phone call in this day and age or a text, because there's a record of that. And you can be criminally prosecuted for a violation of a TPO when you know you have one and you voluntarily violated it without any reason at all. It doesn't make any difference. In addition to that, it is a violation of the TPO to have someone you know contact the other party. Well, I'll just have my friend contact her, or I'll have my mom contact her, or her mom, whatever that happens to be. That's also a violation which you can be held criminally liable and can be criminally prosecuted because of it. Now, I've had many clients who have fallen into the trap where they were contacted by the other party via text or by phone while there was a TPO issued. It is not an excuse to respond to a contact. If you are called by the other party, do not answer. If they send you a text, do not respond. The court can still violate you. The excuse in court of saying, well, they contacted me first, or she called me and left a message, or that she sent a text expecting a response, that will not fly in court. They can still violate you. You have to be incredibly careful when a TPO has been issued. And I'm stating when a TPO doesn't have any validity, because I believe throughout most cases, you find out that they really don't. There really wasn't any threat, but someone was just mad at the other party and they wanted to put an exclamation point on their anger. And those things generally are not verified until you have a hearing approximately 30 days later after you've been served with it. So the process of the TPO is that you'll get served with the TPO and then you set a hearing approximately 30 days later to be heard on what it is, and courts generally do not issue them beyond that. Sometimes they do. when they find that there is just cause. But that depends on what the situation is, and that depends on what's going on. But most TPOs are dissolved rather quickly, and you can move up that date by an order shortening time if the court will permit it and upon good cause. So the main thing to do is when a TPO is issued and served on you is to cease any and all contact and abide by that religiously. Do not violate the order. Once again, this is Kurt Harris with the Men's Family Court column. I look forward to speaking to you in the near future. Thank you.